Hello everyone, I'm Devojit Das and welcome to Courts Today by LiveLaw, your daily roundup of the biggest legal developments across India's courts. From politically sensitive matters to rulings that touch everyday lives, we bring you the cases that are shaping law and society. Starting with one of the most contentious stories that moved forward today as Jammu and Kashmir High Court's special bench is hearing a challenge against the forfeited books notification 2025, which the state issued to confiscate certain books deemed harmful or seditious. The petitioners argue the notification is vague, overbroad, and has been used to censor books arbitrarily without due process. During recent hearings, the court questioned the government's basis, which exact books are forfeited, why, and whether authors or publishers were heard in advance. The government's counsel said that the notification is aimed at curbing radical literature and maintaining public order. The bench pushed back. They asked for clarity on the criteria used, demanded justification for seizing books before trial, and wondered if this gives the state sweeping powers to suppress dissenting views. The court has sought detailed replies and listed further hearings soon. Moving on to the Madras High Court, as it reserved its order on anticipatory bail petitions filed by TVK party functionaries in connection with the tragic Karur Stampede on August 2025. Which claimed over 40 lives at a public meeting. The stampede occurred during a campaign rally organized by the party, and the state has invoked serious charges, including culpable homicide not amounting to murder. During the hearing, counsel for the accused argued that they were organizers and not direct participants in managing the crowd, and that their presence was voluntary and purely political. They urged the court to grant interim protection, citing absence of past criminal records and the need for fresh representation. However, the High Court judges pressed them hard, questioning their role in crowd control and safety measures. The bench asked whether they had any duty or control over barricading, marshals, exits, or arrangements for medical aid during the event. The state's counsel countered that the accused had influence over organizational logistics and must answer for lapses that contributed to the stampede. Though no final decision has been delivered yet, the Supreme Court's keen scrutiny of anticipatory bail in mass casualty cases in recent years suggests the Madras bench will subject these pleas to rigorous testing. The outcome will signal how far legal protections extend to political actors in large public events gone awry. Next, we take a look at an interesting development from the Madhya Pradesh High Court as it dismissed a plea by a doctor with a Bachelor of Ayurvedic Medicine and Surgery that challenged the state government's refusal to grant sanction to prosecute health officials who had searched and inspected his clinic in Ujjain, calling the doctor's complaint nothing but an effort to harass public officers doing their duty. So here are the facts of the case. The doctor and his wife, both qualified as bachelors in Ayurvedic medicine and surgery, had run a clinic for almost 2 decades in Ujjain. On May 18, 2011, an inspection team allegedly entered their clinic and found that they were admitting patients, administering IV drips and injections, but lacked a certification from the Chief Medical and Health Officer. They were also found in possession of large quantities of allopathic medicines outside their qualified Ayurvedic scope. Following that, the clinic premises were sealed and the CMHO later allowed the clinic to operate on the condition that they stop using allopathic treatments and register themselves properly first. Later, the doctor filed a criminal complaint under sections 341, 355, 451 and 500 of IPC, read with section 34, against the inspection team alleging wrongful restraint, trespass, defamation, and more. But to prosecute public servants for acts done in the discharge of their duty, Section 197 of CRPC requires prior sanction from the government. The doctor's request for such sanction was refused. He then challenged that refusal before a single bench, which upheld it, and the matter reached the division bench. The division bench of Chief Justice Sanjeev Sachdeva and Justice Pawan Kumar Dwivedi noted the sanctioning authority's clear findings confirming the inspection team's actions pursuant to government instructions to curb medical quackery. The doctor did not deny the inspection report's findings regarding allopathic medicines. The court also observed that there was no suggestion of personal enmity, fabrication, or malice against the inspecting officials. Given all this, the High Court held that interfering with a sanction refusal would be inappropriate and declined to overturn it. This ruling sends a strong message. Protecting public officers doing their lawful duty is also critical, and sanction bars exist to prevent frivolous prosecutions against them. Moving on to the Bombay High Court that had to intervene to protect a jewelry brand from a smear campaign online. In an interim order, the court directed social media platforms to take down posts labeling Malabar Gold and Diamonds as a sympathizer of Pakistan. So here's the backstory. Malabar had hired a Pakistani influencer known as Alishba Khalid to promote its brand in the UK. Some netizens later dug up her prior criticisms of India's Operation Sindoor and began accusing Malabar of being anti-national. Malabar, however, says it hired her before those statements came to light and claims it wasn't informed of her background by the agency. The brand urged the court to stop competitors from using this to damage its business, especially ahead of festive sales. The court agreed that social media content portraying the brand as a traitor could hurt its reputation and goodwill. In its order, the court noted that Malabar has discontinued the influencer's services and that the brand cannot be held responsible for all her actions. But that doesn't excuse baseless attacks. So the court ordered immediate removal of the offending content. In a decision worth noting today, the Calcutta High Court granted bail to former Education Minister Partha Chatterjee, accused in the state's recruitment scam. The judgment comes after he was arrested in September 2022 in connection with alleged irregularities in teacher recruitments and appointment processes. The court considered several factors. Chatterjee has already spent considerable time in custody. He has long-standing roots in the state, and he has cooperated with the investigation so far. The bench also noted that the charge sheet in the case is complete, reducing the likelihood of flight risk or tampering with evidence. Importantly, while granting bail, the High Court imposed conditions that Chatterjee must surrender his passport, furnish a bail bond, and appear in court as required. The bail is granted pending trial, meaning all allegations will still have to be tested in court. Next, in an ongoing development for moviegoers to take note of, the Karnataka High Court has declined to lift a stay on the single judge's earlier order that halted the state's new 2025 amendment rules capping movie tickets at 200 rupees. To give you context, on September 23rd, a single judge had stayed those rules, which sought to fix ticket prices uniformly across theatres, including multiplexes, pending further hearings. Now, a division bench of Justices Suraj Govindaraj and Rajesh Rai refused to undo that stay. But they did more. They expanded the interim relief to protect the interest of all moviegoers and theatres. They directed the Multiplex Association and its member cinemas to maintain accounts of every ticket sale, excluding GST, whether booked by cash or online, and submit monthly statements to the licensing authority. If the multiplexes lose the challenge later, the bench said the amounts collected electronically could be refunded to ticket buyers to protect consumer interest. For cash transactions, the court will deal with those later after merits are heard. The court also made the order public. Multiplexes must display the interim order prominently in auditoriums before movie screenings. In refusing to lift the stay, the bench effectively held that the single judge's concerns about the state's power to fix the ticket prices, that is, whether the statutory law allows such regulation, and potential arbitrariness must be examined in full, not prematurely overridden. This decision keeps the status quo intact for now, but signals the court will carefully scrutinize whether the state had the legal authority, data backing, and fairness before imposing such a sweeping price cap. And finally, the Delhi High Court has reaffirmed that Indian courts are not barred from executing a foreign decree pending enforcement abroad. The court emphasized that parallel execution is permissible under Section 44A of the Civil Procedure Code, which allows foreign decrees from reciprocating territories to be executed in India as if they were passed by an Indian district court. Justice Purushendra Kumar Kaurav highlighted that the phrase "as if it had been passed by the district court" necessitates assuming the decree was issued by an Indian court, thereby permitting simultaneous enforcement in both jurisdictions. This approach aligns with principles of comity and reciprocity, aiming to prevent judgment debtors from dissipating assets in one jurisdiction while proceedings continue in another, thereby safeguarding the rights of decree holders. The case involved the enforcement of a decree from Sharjah Federal Court in UAE, directing the judgment debtors to pay approximately 991 crores. Despite the pendency of execution proceedings in UAE, the court allowed parallel enforcement in India, reinforcing the principle that enforcement should not be hindered by proceedings in the cause country. This decision emphasizes the judiciary's commitment to facilitating the enforcement of foreign judgments and protecting the interests of decree holders across borders. That's all for Courts Today by LiveLaw. Stay tuned as we continue tracking how the courts are holding power to account, protecting rights, and shaping the future of justice. Thank you for watching.